You launched first, you built the product, you own the domain, you've been using that specific brand identifier, whether it's a name, a logo, a sound, a color. You've been using it for the past however many years. And then all of a sudden you receive a cease and desist letter from a company you've never heard of, saying that you are infringing on their intellectual property right, their trademark, by using that brand identifier or by using that name. And you're wondering, but I started using it first. That is not a protection in law. Today we're going to be talking about the fact that using a trademark for 100 years without registration is not a defense in law. Really, it's not. Because, in my practice, I've seen that founders often assume that first to market, first use of that thing equals ownership. In some common law states, yes, there are some certain rights that you can get from, being the first to use that particular thing. But those rights are very, very narrow and they're very limited. And they don't even afford you to the maximum extent of the protections that you would need, especially if you're building something in a competitive industry or niche. A registered trademark grants you national rights, sometimes even international rights, depending on where and under what treaty or convention you registered it in. It grants you stronger remedies. It helps with faster, easier procedural enforcement of your rights to that trademark. And it is essentially a public notice of ownership saying that, hey, this is mine and I would fight to protect this very thing. But when you have not registered your trademark, you are just using it willy-nilly and someone else registers it first, then all of these benefits will accrue automatically to the person, and that risks the very foundation of your brand ownership, because now it's no longer a case of, oh, I own this thing. Now it's you being in a defensive position, trying to defend the fact that, okay, I have been using this name for however many years and so cannot come and take it from me. You put yourself into a defensive position and you lose the leverage that you would have had you registered that trademark at the time that you were supposed to have registered it, in the class that you were supposed to have registered it in the jurisdiction, in the appropriate jurisdiction that you ought to have registered it in. And you find that rebranding yourself at that stage, whatever stage it is that you have grown up to, rebranding at that stage goes beyond mere cosmetics now. Now it's a full-on infrastructural systemic rebrand of your product, of the goodwill that you have built. It becomes very tedious to start unwrapping all of, those things. As a founder, the moment you think of an idea, the first thing you need to do is register your intellectual property in that industry, within the specific jurisdiction and in the appropriate classes. Because if you do not do that, you can lose the product and lose the goodwill that you have spent time, energy, and many other resources cultivating. So your takeaway here is that registration of your intellectual properties should no longer be an afterthought. It is a strategic, administrative, legal task that you must do now, so that you don't lose the brand that you have spent so much time and energy and resources building.